Thank you first and foremost for attending, and welcome to the fourth and final in a four-part ACMEC webinar series where we are tackling the implications of professional licensing for condominiums, corporations, and as we're talking about today, this includes self-managed condos. My name is Tony Reed. In my professional life, I am a Senior Vice President at BFL Canada in the Real Estate Division. I'm also a board member of the Canadian Condominium Institute, National Executive Board, and a board member of the Alberta Condominium Management Education Consortium, or as we call it, ACMEC, which is the host of this webinar series. ACMEC is a Canadian not-for-profit joint venture between CCI North Alberta, CCI South Alberta, and the Alberta Real Estate Association. ACMEC was created to offer high-quality condominium management education for industry professionals by industry professionals. I would like to start by acknowledging that Alberta is the traditional and ancestral territory of many First Nations, Métis, and Inuit peoples, and express gratitude for the traditional knowledge keepers and elders who are still with us today, and those who have gone before. We make this acknowledgement as an act of reconciliation and pledge to address systematic racism. I would also like to take this opportunity to thank the Alberta Real Estate Foundation for their generous grant that enables us to deliver this series without charging. For more information on the work that AREF does, please visit their website at AREF, that's AREF, .ab.ca. For those of us in the Alberta condominium community, the implementation of condo manager licensing has generated a lot of questions and caused uncertainty. This webinar series was developed to be a resource to condo boards, managers, and owners. We are hosting experienced subject matters who provide their insights about what licensing means for the condo community, answer arising questions, and inspire certainty in a newly licensed industry. If you like what you see today, please make sure to check out the other 3 previous videos that we have presented, and they can be found at acmec.ca. That's acmec.ca. Now, just a few housekeeping reminders for everyone in attendance. The audience cameras are off and the microphones are muted unless prompted by the host. Please type your questions in the Q&A panel, and if we can, please keep the chatter polite. Questions will be answered at the live question and answer following the presentation. As mentioned, we are recording this webinar, and we will share the recording link with all participants. We will also be sharing this recording and all the others in the webinar series on the ACMEC website or at acmec.ca, so they can be accessed in the future. With that, we are pleased to bring you the expertise of 2 of my colleagues who have over the next hour, that is Roseanne and Dionne Levesque, will be walking us through the distinction between licensed and unlicensed activity and where you can go for resources to assist with management activity of licensing. Before we get started, though, let me share a little about our presenters. Rose has managed a variety of commercial, condominium, homeowners association, and residential properties, and is well known in the industry by her colleagues for her positive attitude, her willingness to share knowledge, strong ethics, attention to detail, and for setting a high standard for personal goals. Rose has a vision of lifelong learning, which has led to her volunteer involvement with industry-related organizations. Rose has also achieved her Certified Property Manager and Accredited Residential Manager designation from the Real Estate Institute of Canada, AMO accreditation awarded by the Institute of Real Estate Management to the top professionals in the industry, along with her Accredited Condominium Manager designation from the Association of Condominium Managers of Alberta. Rose was awarded the Bentel Award of Excellence during 2007 and the REIC Edmonton Chapter CPM of the Year Achievement in 2015. Dionne was born and raised in Calgary, and prior to entering law school, she received her Bachelor of Science in Psychology with honors from the University of Calgary. She attended law school at the University of Victoria, where she was awarded her JD degree in 2007. Dionne also holds a certificate in international business law from Queen's University and has completed a program in international property law at Oxford University in England. After graduating from law school, Dionne articled and practiced at a prominent Calgary law firm, primarily in the area of construction, condominium, and real estate. Dionne joined Scott Venturo Rudakoff LLP in 2016, where she maintains a practice that focuses on real estate, condominium, and development law. She regularly represents sellers, purchasers, banks, and developers in acquisitions, sales, and refinances of personal, commercial, and investment property. In addition to her real estate practice, Dionne acts for individuals, board of directors, property managers, and developers with respect to various condominium matters, including insurance claims, bylaw creation and interpretation, bylaw enforcement, and condominium disputes. Additionally, Dionne sits on the CCI chapter for Southern Alberta as a board of director member. With all that now, we'll hand it over the reins to Rose and Dionne to take it away. Over to you, ladies.
Thank you, Tony, for that introduction. My name is Dionne Levesque. I am just going to go over the agenda and then hand it over to Rose, who is just signed on as well. So what we're going to go through today is the RECA complaint process, the types of complaints that can be made and accepted, the types of sanctions that can be levied against managers if they're found guilty of sort of improper conduct, legal considerations, and then we'll have some time to go through some questions. Rose, I'll let you take it away.
Thanks, Dionne. So has anyone here ever needed to engage in disciplinary process but didn't know where to begin? That's our first kind of thought process. I'm sure some of you or all would be uneasy to get that phone call from RECA to say, they've received a complaint against you, your board of directors, or in general, one of your licensees, which will be further investigated. No doubt this is serious. However, the more you know about the process, the lesser the anxiety, of course. Or how about if you want to initiate the process yourself and you have no idea of where to start? Well, we can walk through that complaint process. RECA has received a complaint, firstly, let's say, with respect to an ABC condo management brokerage from the board of Pine Grove Condominiums. Here's an example. Pine Grove Condominiums claims that ABC made a false disclosure statement. If after an initial review, the complaint meets the criteria for investigation, RECA will notify the complainant and the licensee that it's commenced an investigation. In this case, both ABC and Pine Grove, as no witnesses were involved. They may also reach out to notify the broker and brokerage at this time or at a later date. If this is a self-managed condominium, rather than a managed one with ABC management, and the complaint was regarding a false disclosure made by the board of directors, RECA may or may not notify the board of directors directly. In this instance, however, Pine Grove is professionally managed by ABC Condo Brokerage.
And just to add to Rose's comments on there, RECA really should not be investigating board and owner complaints where there's no manager involved, because technically they don't have jurisdiction over strictly board and owner complaints. They just have jurisdiction over complaints with managers. So it doesn't mean that they won't investigate or open up a file, but normally they shouldn't. Also, a quick comment, if you are a licensee and you're an employee of a management company on this call, and I know there's not many, I would recommend reaching out to your broker as soon as possible if you do receive a complaint. And there are a couple of reasons for this. First, as an employee, you're likely obligated to advise your broker of any professional complaints under your employment contract and for insurance purposes. And two, your broker might be able to step in and give immediate assistance. And three, Of course, the service contract between any management company and a condominium is between the broker really and the condominium. It's not between the individual property manager and the condominium. And so complaints to RECA usually are about the provision of services. And of course, everybody needs to know, or your broker needs to know about anything that affects the services being provided to the individual condominium and any complaints received in that regard.
Thank you, Dionne. So as an example of cooperation and interference could be ABC Condominium Management broker is notified by RECA regarding a complaint against one of their licensed associates and an informal or a formal follow-up letter. They are asked to provide the following for a specific date. Provide your detailed written description of the events described in the complaint. Provide a detailed written description of any conversations you had regarding a specific incident. Please provide any other documents or information relevant to this matter. The specific date indicated within the letter either passes without any response or the response given contradicts proven facts. You are given the opportunity to clarify, after which time you further provided details that you had not confirmed as correct, which contradict previous details given, while also leaving out details which are later determined as relevant to the investigation. To cooperate with the investigation, you simply need to provide the known facts without fabrication by the specific date requested. Should you have required an extension, you could have asked for it and may have received it dependent on the circumstances. Refer to an information bulletin by RECA in the handout that was last revised April 2014. That's inserted in your chat section right now as well. It explains the industry professionals must not interfere with an investigation process.
And my additional comment on this is, no matter whether you're a broker or a licensee, an employee responding to a complaint, or whether you're a board or an owner and you're contemplating making a complaint, there are two things to keep in mind that I think will greatly assist you. Number one, document retention. So this is the same as what lawyers tell all clients. If you suspect an issue may be coming up, make sure that you have all of your relevant documents related to the matter put aside in a file. Try to keep everything in writing. Email is fine. Personally, I won't respond to difficult parties via the phone, because then there's always a he said, she said scenario that could occur. Or if you do have to get on a phone call with somebody, and again, you suspect a complaint might be coming up, have somebody else in the room so that they can attest to what was and was not said on your side. To remember that the devil is in the details in any type of complaint scenario. This area, condominium management, is a relatively new area for RECA. I haven't actually assisted any party in making a complaint to RECA, but I have assisted a couple of managers in defending some complaints. And from RECA's perspective, I think it would make their job a lot easier if, again, whether you're the owner or the board or you are the management company, you can point to specific evidence and specific bylaws or specific provisions of the Act that you believe have been violated or not violated in the case. For example, there is a big difference between an owner simply stating that manager X doesn't send out financial statements in a timely manner versus saying Section X of our bylaws requires the condominium corporation to send out financials for the owner's review every month. I have asked the manager for the last 3 months of financials on the following dates, and we have not received a response. Like, that's a lot easier for RECA to respond to. Similarly, or I guess conversely, on the manager side, there's a big difference between saying, we've reminded the board numerous times that they have to approve the financials so we can post them, versus saying, we have reminded the board on X date, Y date, and Z date that they need to give us authority to post the financials. And then as evidence, here are all our emails to the board. Section 8X of our contract requires approval of the board before we can post financials. We have not received a response from the board to date and therefore unable to post financials. That just completely streamlines the process for RECA. It's almost like setting your case out in advance, and I find that that sort of nips some of these complaints in the bud. Trained investigative staff will typically gather the facts carefully, fairly, and objectively. They may interview the complainant, the licensee, the board of directors, and any other necessary witnesses during an investigation.
So RECA keeps the information obtained during a professional conduct review confidential, as far as the professional conduct review process allows. However, if the matter goes to a hearing or to a prosecution, the information may become public and the complainant may be asked to testify. You may be wondering how long it can take. In 1 to 2 weeks to acknowledge a complaint received, typically 1 to 3 months to resolve, some much longer though, depending on the investigation required.
And I would just add that it seems like RECA's investigation powers are quite broad. So I would recommend complying with their investigators' requests. And this is certainly not the time to provide less information. You definitely want to provide the most information that supports your case, no matter which side of the complaint that you're on. Interesting comment regarding public knowledge. So these complaints can be publicly published eventually. This can be a double-edged sword to keep in mind for the complainant, which is sometimes the condominium board. It's not always great as a condominium corporation to have your dirty laundry publicly aired, because of course it can affect resale value if a real estate agent does a Google search and your condo is at the center of a dispute. We see this in condominium law all the time, even with owner and boards disputes. And this happens with cases unrelated to RECA. Same consideration at play with management companies. It's not really good business practice to have a number of complaints made against you and posted on the RECA website. Sometimes just the sheer publicity of a complaint process, or I guess the fallout of that, can be worse than the actual penalty itself. Remember too, that in the investigation process, no one can interfere with the complaint process. So this probably goes without saying, but you can't tell somebody not to make a complaint. You can't offer a reward or benefit or even discounted services to encourage somebody from not making a complaint. No one, of course, can threaten a witness, and you can't threaten to sue somebody for making a complaint. All of those are considered interference, and my understanding is RECA takes that quite seriously. Interestingly, you can't also settle a lawsuit by asking somebody to withdraw their complaint.
Thank you, Dionne. So the investigative staff will provide the facts and evidence gathered to the executive director to make a decision. The decision may result in no action, an advisory note, a letter of reprimand, an administrative penalty, a referral to a hearing panel who will make a decision after a hearing and statements and evidence. In this case, ABC Condo Brokerage received a letter of reprimand. RECA notifies all parties of the outcome. It can take 1 to 2 weeks to acknowledge a complaint received, 1 to 3 months to resolve, so much longer through depending on the investigation. So there's some more details here as well with respect to included in your handouts that will be in your chat link here, which will be the RECA complaints, the RECA guide as well, and the hearing and appeal practice and procedures. Those are very important to review if you're going through that process.
My additional comment on this one is that historically, a big issue that has arisen for realtors and which may now arise for managers is the issue of costs, meaning the costs that may be awarded against a manager if the manager either is complained of and then loses a hearing or an appeal. Because that manager can have, or RECA, the hearing panel can award costs as against the manager. The cost could also be awarded if a member even admits to conduct deserving of sanction. The costs that hearing panels can award are, there's quite a few different headings of that. So they can award the costs of investigation, and there's a guideline that says between $40 and $80 an hour. They can also award the costs of the registrar's internal legal counsel, that would be RECA's counsel, up to $250 an hour. Independent counsel costs, if that was necessary on either side, up to $250 an hour. Hearing panel honorariums, hearing administrator costs, and witness conduct money, expert witnesses can be awarded up to $1,000 a day. So there is a guideline, but for example, if you are fined $1,000 and you then want to proceed with an appeal to a hearing, the guideline actually indicates that you could be dinged with $2,000 in costs if you then lose that appeal hearing. So unfortunately for smaller fines, the system seems to be a little bit one-sided, which means that it won't be or may not be worth it for managers to challenge smaller fines or letters of reprimand, even if they believe that the fine against them was wrongly issued. Now, you can appeal hearing panel decisions. The basic process for appealing a decision is that the manager, well, there seems to be two processes, and so RECA is a little bit convoluted when it comes to this. But if you're appealing a hearing panel decision, you can appeal that to a RECA appeal panel. That can then be appealed to the Court of Queen's Bench, and then if they don't like that, then that can be appealed to the Court of Appeal, and then of course the Supreme Court of Canada, which nobody's ever going to get to. Now, when it comes to sanctions, it looks like you can appeal to a hearing panel, but on review of the legislation, it says that the hearings panel's decision is final. So that may mean that your remedy would be judicial review before the courts. In any event, the point being, if you get to that point, it's probably best to consult with legal counsel before proceeding, so you take the right actions.
Great, thank you, Dionne. The condominium management industry in Alberta is self-regulated. That means it is an industry that regulates its own members and enforces standards as opposed to being regulated by the government. The Real Estate Council of Alberta, RECA, is the mechanism through which self-regulation occurs. So we can refer again to another handout on self-regulation to see what that means in your chat as well.
And of course, this is similar to lawyers, doctors, engineers. The basic requirements of being part of a self-regulated or industry are that you need to be knowledgeable in your field, and you must comply with the standards of professionalism that are established by that regulatory body.
And now I know we're all wondering, with the new licensing of condominiums and RECA being involved, should I expect frivolous complaints investigated and taking time and effort and causing undue stress? What type of complaints may be investigated? On the other hand, what do I need to know about complaints that I should be submitting for review and possible investigation? So firstly, the answer to the first question is definitely not. RECA does not investigate, as Dionne mentioned earlier, complaints that are related to services provided by condominium, the actual board of directors, or the complaints being provided by condominium management brokerage and condominium managers. They do. Unlicensed practice, they do as well. They do not regulate board decisions or actions, CPA or CPA regulation, frivolous complaints, complaints with insufficient evidence. There's also where we can again refer to more handouts. Sorry, guys. It's a lot of handouts, I know, but it can help you if you get through that process. The link for the RECA information bulletin that was last revised December 2022, and that's with respect to complaints for condominium management. It can actually really help walk through that process. It explains the condominium related complaint issues that the Real Estate Council of Alberta is able to respond to and the process they follow when responding to complaints. The alternative dispute resolution services as well through RECA. There is also a handout for that. Minor complaints within RECA's jurisdiction that may be referred to the broker for review and resolution. So that's really another process that can maybe avoid an investigation is to actually be corrected on a minor matter through the brokerage. So that's more informal. If it does not fall under their jurisdiction, through the VBRP, they call it. If it does, this is in the latter case of the requirement of all parties to consent, though in writing. So a complainant doesn't have to go through that process. A brokerage doesn't need to go through that process. They can go directly to the investigation if they like. So there is the guide for brokers, and that is another addition into your chat. If the voluntary broker resolution, the VBRP, resolves the complaint and all parties are satisfied, RECA will terminate the investigation.
And I think we all need to remember that this is a new area for RECA as well. Condominium management is quite different than what RECA has previously governed, which is mostly the governance of realtors, brokers, and I believe previously appraisers, although they've been taken out of the equation. The big difference being with realtors and mortgage brokers, the relationship is more of a one-off. So, you know, if you have an unsatisfied client, okay, well, that's just one person and you move on to the next party. Whereas with condominiums, the relationship and the management contracts are, of course, in place for a much longer term. The services are different as well. Condominiums provide services to not only boards, but also technically they're providing the services to the individual owners in the complex in addition to the boards. The duties that a manager owes to individual owners seems to be a bit of a gray area right now. Managers are the agent of the condominium, so they take instruction from the board of the directors of that condominium, and they have an agency relationship with the board. So they are the agent of the board. They are acting on behalf of the board. Managers don't take instruction from individual owners, but they do still have to manage the condominium in a competent manner. And I'll talk more on this later. With respect to frivolous owner complaints, RECA does have the power to dismiss these at the get-go if they deem a complaint frivolous. I have had cases where complaints have been made against managers just simply based on an incorrect understanding of the law, and a simple letter explaining things back to RECA seemed to resolve the complaint, rather than having RECA go through numerous interviews in the whole investigation process, which of course can be time-consuming, and time is money for everybody. So that might be a solution if an owner complaint that the manager receives is considered to be frivolous. And yeah, I'll talk a little bit more about contracts in a bit.
RECA does advise homeowners if you have issues with your condominium manager, you should talk to the board first. If your issues are not resolved, you may file a complaint against the condominium manager with RECA if you believe they have violated the rules established by RECA for condominium managers. So to file a complaint with RECA, you can download and print the complaint form and send the completed form to the conduct review at reca.ca. So that's just CONDUCTREVIEW at reca.ca. Insert it into your comments, or by mail. You must identify the licensee you are complaining about or provide a detailed account of the events. You must support your complaint with as much relevant information as possible, including copies of any relevant documents, names, and contact information of any witnesses, any other information that may be relevant to the complaint. So we have another insertion is the complaints condominium management .pdf reca.ca, which provides further details on the complaint process. Lots of information and support here to walk anyone through the process, not to be too overwhelmed, although it is a lot. You can seek legal advice, of course, and you can also reach out to RECA to discuss your matter further for informal advice before submitting a complaint. You can go through the general consumer and industry inquiries through an email at info@reca.ca, or you can call their number out of Calgary, 403-228-2954, press number 4. There's various policy and legislation as well governing operation of brokerages in Alberta. Licensees should familiarize themselves with the legislation impacting their role as a licensee. A licensee needs to know what a breach of any regulatory body is likely to result in an investigation by RECA. And an example of common crossover is Alberta Human Rights Act and Occupational Health and Safety Act. We can refer to resources in the handouts for an extensive list in that area as well.
Also, don't forget the new Home Warranty Act. That's really important with condos that are less than 10 years old. And managers hopefully are aware of warranty deadlines. Sometimes the condo isn't aware of its own warranty deadline, so keep that in mind before you place too much responsibility on the manager. I would recommend that if you are a manager on the call, specifically with respect to warranty deadlines, that you should be considering documenting to your board that you have warned them and advised them of any applicable warranty deadlines. Now, just a comment with respect to the legislation and the knowledge requirements of managers generally. Even as a lawyer, I can't tell you every single provision of the Occupational Health and Safety Act or the Real Estate Act or the Alberta Human Rights Act. And I even under for example, the Alberta Human Rights Act, the case law is continuously evolving. Things are changing over time, and it's difficult to be on top of everything and know everything all at once. So there are clearly obvious cases where managers should know one thing versus another. For example, clearly you can't have a condo enacting a bylaw that prohibits all women, for example. But there are also some gray areas where the answer may not be clear. And my advice to managers would just be to be aware when you're not sure of something and to then recommend to the board to get a professional involved, whether that be a lawyer or an engineer or an insurer or an accountant or somebody who can give the board independent advice on that issue.
There is an information bulletin which explains the types of conduct deserving of sanction as well. And that will be in your comments chat. Some things people may not realize is conduct deserving of sanction. Do you think this is deserving of sanction? On her license renewal application, Shania answers yes to the question about insurance coverage when the real answer is no. The answer is yes. Conduct deserving of sanction could be if you answer no or yes to one of the questions on your license renewal application that should have been the opposite regarding insurance coverage, regarding criminal proceedings, or bankruptcy. Let's try another one. At the request of the board of directors for the corporation he manages, Bryce places a caveat on a unit for unpaid fees. Yes, this is also deserving of sanction. Bryce is taking unlawful direction from a condominium corporation board of directors when he ought to know the Condominium Property Act.
And as I previously mentioned, the manager is the agent of the condominium, which means they have to take instruction from the board of directors. But then at the same time, they have to provide competent service and must practice in accordance with the Condominium Property Act, condominium property regulations, the condominium bylaws, rules and policies that are enacted, the Alberta Human Rights Act. There's just a whole bunch of legislation that's involved. This can put a manager in a bit of a predicament when their client, the condominium, is requesting them to do something that is not permitted, such as the example above. What does a manager do if the board is instructing them to file a caveat for a fine when they know it's not permitted under the Condominium Property Act? RECA has issued a rather helpful bulletin that addresses these type of issues. It's entitled Unlawful Instructions from the Chair or Condominium Board. And if you Google that, it should come up, but we will put a link in, I think, at the end. The bulletin itself recommends that managers follow these essential steps. Number one, alert the condominium to the potential issue. Number two, if the board decides to go ahead anyways, then the manager should express their concern in writing. So they've got a documentation that they've told the board what they're doing may not be technically legal, and ensure that the concern is made known to all the board members so that you're not just taking instructions for, say, one or two board members. And then if it gets to a point where the manager feels like they just can't comply with the legislation, they may have to consider termination if they feel that they're receiving completely unlawful instructions. You might be able to reach out to RECA in those situations and get some additional insight. I believe there are practice advisors available. And sometimes, for owners to remember, sometimes a board just won't take advice from their manager. In that case, personally, I suggest that the managers try to get a third party involved, because sometimes the board will listen to the advice of someone else rather than the manager themselves.
So true, Dionne. So what types of sanctions may be given? Well, there's a wide range of sanctions RECA may impose to address the conduct of an industry professional, which may include a letter of reprimand, the administrative penalty. They may include penalties related to specific sections of the Act. For example, Section 17, Real Estate Act, equals a penalty to a maximum of $25,000. This could relate, for example, to a person conducting services without an appropriate license for that purpose issued by the Industry Council relating to that industry. For example, offering condominium management services that require a license without holding that license. Fine, a license condition or restriction, a suspension or cancellation of one's license. RECA regulator and public announcements brush up on types of sanctions, reviews that are frequently conducted. You can read through these as they're released ongoing as well. So that's part of your handouts, but I mean, that's also something to realize as well, that those licensees or those brokerages, that's publicly out there for people to see when those decisions are made or those sanctions are made. So your everyday good character, knowing that goes a long way with speaking to your conduct in a review. You got a handout that's also part of your comments here, the professional conduct review. RECA considers the character of licensing applicants before issuing a license. Read the good character policies to learn more about how RECA defines and applies good character to licensing and disciplinary decisions as well. What might good character mean? It could mean no prior sanction, no complaints or investigations.
The responsibilities of licensees, including managers, are all set out in Section 41 and 42 of the Real Estate Act rules. And interestingly, Section 42G specifically has this general catch-all that states, all licensees are, and I quote, not to engage in conduct that undermines public confidence in the industry, harms the integrity of the industry, or brings the integrity of the industry into disrepute. Now, this is pretty general, and it does give quite a bit of discretion to the registrar, to RECA. There is sort of a similar clause in the Lawyers' Code of Conduct and I suspect in a lot of other professional bodies' Code of Conduct, but this may be new for managers. This applies professionally and personally to a degree. So by way of example, I came across a published decision on the RECA website about 42G, and there was an example of a realtor who didn't refund their tenant their security deposit in a timely manner, and they also didn't hold it in trust in accordance with the Residential Tenancy Act. Now, this had nothing to do with the dealing of the realtor. It was a personal contract between the realtor and the tenant, but the tenant did complain to RECA. The realtor eventually returned the deposit. He just returned it late. RECA considered it and did issue him a letter of reprimand under the Real Estate Act because I guess it undermined the confidence or public confidence in the industry. But I just think that's interesting because it seems to hold managers to quite a high standard, or potentially hold people to quite a high standard.
So referring back to the legal advice, when to involve legal counsel for advice. Firstly, I would say on the property management side, for condominium management, anytime you're unsure of processes or what is being requested, anytime you cannot meet expectations, or you are attending a hearing, unless self-representing, so noting in all cases the broker is notified and will be able to assist through that process. So earlier Dionne had mentioned, like, reach out to your broker. You don't know if they've been notified or not, but you need them as part of that process. And do I need legal advice or representation? There is a self-represented program with loads of details and videos on it. That's going into your comments and provided as part of your information as well. And there's a whole ton of modules here. So how the panel chair starts a hearing. Module 2 is on making an opening statement. Module 3, questioning a witness during direct. What do I need to know about submitting a complaint for review and possible investigation? Normally, complaints about condominium management services, as was mentioned, should come from the board of the condominium corporation, making a closing statement. Module 8, preparing a written submission for sanction and costs. So very helpful there.
And I would just reiterate that condominium managers are, of course, different from realtors and brokers in the sense that they have these long-term ongoing contracts with boards. So whereas those realtors or brokers can just move on to the next person, an unlawful termination of a management agreement can have quite significant financial consequences to both the manager and the board / the condo. For example, a manager could sue for payment due to the end of the term of its contract if it believes that its contract has been unlawfully terminated. A board, on the other hand, could sue a management company for the cost of having to employ a new management company at a higher cost for the basically at a higher rate, if it believes the management company unlawfully terminated its contract. So this does put managers and boards in a bit of a different position than your standard realtors and brokers. The other issue I would say the boards and managers probably need to consider just temporarily is that there does seem to be a bit of a lack of managers in the province just due to staffing shortages that everyone is experiencing, and in part due to the implementation of the RECA requirements in the exams. This has sort of weeded some people out, so to speak, and made it more difficult to become a manager, which is good generally, but does have some difficult implications in terms of finding and hiring employees. So as a result of all of this, I would very, very strongly encourage both boards and managers and owners to attempt to resolve disputes first without going right to RECA as your initial step. There's really nothing better to undermine the confidence in a relationship in a manager than going right ahead and reporting them to RECA, to their professional body, which at core is an allegation that they acted improperly. And if such an allegation is completely unfounded or frivolous against a particular employee, it could even be considered a form of harassment. I would also point out that, and just be careful, boards and managers, that some management agreements do have indemnification clauses whereby managers are indemnified against costs associated with responding to frivolous or unfounded complaints to their professional body. So if you are a board, I would be sure to review your management contract before a complaint is made. Or if you're an owner, I would be sure to maybe consider this before you make a complaint, because you could be paying for your manager's legal costs, again, if the complaint is completely unfounded. If you are an owner on this call, keep in mind that even RECA itself encourages you to first go to your board of directors to resolve the matter. Because typically it's the board who should be making a complaint to RECA, not the owner. And very often I find that the manager ends up being a bit of a scapegoat for the board's decisions. So it's actually the board making the decisions, the manager's just the messenger and they're relaying the decisions. But as owner, my apologies on my phone, you're just dealing with the manager, so you think it's the manager who's making the decisions, when it's actually not. I would recommend having a look at RECA's bulletins. There's a whole bunch of bulletins that they've published on condominium management services. There's a lot of information in there about how the Real Estate Act affects condominium management. There is also quite a lot of legislation surrounding the Real Estate Act. And I find personally it's not very well consolidated because we have the Real Estate Act, we've got the Real Estate Regulation, we've got real estate rules, we've got real estate bylaws, and then we've got all of these interpretation bulletins and things posted on RECA's website. And there seems to be bits and pieces everywhere, and it can be hard to navigate. What I've really drilled down to when it comes to complaints is there's a few pieces of these legislations and acts that are important. One of those is under the Real Estate Act, Section 37, 39, and 83. If you're kind of a real estate or if you're a law geek and you really want to go to the core legislation, those are important because those set out RECA's investigation powers and potential consequence powers. And then Section 41 and 42 of the real estate rules sort of set out the expectations of a manager or a licensee and what standards that they should adhere to. And finally, this is really important because I think this is one of potentially the worst consequences that a condo could find themselves in, is if a condo thinks that there's some sort of breach of trust. If the condo thinks that the manager has taken funds, which has happened. I think I've only heard of one case in Alberta, but it has happened in the past. In extreme circumstances such as those, RECA actually does have the power to freeze accounts. It has the power to freeze accounts if it believes there's a trust issue, so like there's less money that's supposed to be in a condo's account, or if criminal proceedings are being instituted, and I think there's something else. But again, if that's an issue, make sure that you report to RECA right away if you do perceive that there are any trust issues. There may and there may not be. But if there are, and you have substantive evidence to believe that there are, it's best to get RECA involved. And I think that might be the end of our presentation.
Yes, thank you, Dionne and Rose, for your expertise, for taking time out of your busy schedules to help us all learn. We do have a couple questions. The first one was, what happens to the broker or condo manager if they are not licensed after September 30th?
Ooh, that's a good question.
Yeah, I understood that the conditions, if they're not removed, then you're downgraded. If you have another license, then you're just downgraded to that one license that you have, unless you've been given an extension by way of let's say, for example, taken 2 of the exams, you've taken the course, then you have to re-register for the course again if you haven't received any extension or exemption. So you have to check with RECA.
Yeah, and if you're a manager, in theory, you could work in a different capacity under an employee, but if you're a broker, you wouldn't be able to provide services as a broker.
No, the broker would need to essentially hire another broker.
Perfect. Thank you, guys. Another question has come up. Have there been many complaints filed with RECA? And does RECA provide statistics on complaints?
I wish I knew the answer to that question. I don't. Neither Rose nor I are representatives of RECA, and so our review of the legislation is based on an outside-in perspective. Personally, I think I've only seen a handful of complaints, like under 5, that have come to my office. That doesn't mean that the complaints haven't gone to managers directly. Rose?
You can actually receive the information that's released out if you go to the RECA site. I know that they put out those information on any of their decisions. And even as you say, like a handful, I would say that's all I've seen, and they've been pretty minor.
Perfect. Thank you, ladies. There was more of a comment made here that mention was made of the board not listening to the manager, suggesting that the manager is always right. Sometimes the manager does not give good advice, and the board must be prepared to assess the advice and challenge if necessary. I think I would just reference Dionne and Rose's point that, on this one, that, the subject matter should be consulted with this, whether it be, bank, real estate law, whatever it is. Turn to the professional. It's hard for the manager to know absolutely everything. Is that a fair comment, Dionne and Rose?
Yes, and that probably maybe was a bit directed a bit at me, and I wasn't certainly intended to say that the managers are always right. But the problem is you have this long-term contract with your manager. So what do you do when you're fighting with your own manager? And in those situations, there's a couple of resolutions. Number one, you can reach out to the broker and express your concerns, and maybe they'll switch out a different person for your particular condo. Or you could suggest getting a third-party opinion, and that way it takes the pressure to, kind of gets rid of this back and forth between the board and the manager, and somebody else kind of provides their 2 cents.
You were mentioning about the documentation of, what information has been provided to the board. And I think the board could do the same thing. What information did they consider? And just make sure that information is put into your minutes of what recommendations were given, what you considered, what decision was made.
Yeah, I don't know if I've ever met anyone who knows everything. So are self-managed condos exempt from RECA?
If they're just managing, if they're managing themselves completely and there's no management company involved, yes. And I believe, and maybe Rose can correct me, if the manager is just doing the financial aspect, I believe that is also included in the exemption. Do you know the answer to that, Rose? So if you have a situation where you've got, say, like a 10 unit, and then you're hiring the manager just to do the financial aspect, I think there's an information bulletin from RECA stating that that provision of just the financial aspect is also exempt.
Yes, because when you think about it, sometimes they'll just hire a bookkeeper, for example, even.
Another question is, why does RECA not get involved in fraud involving the board of directors?
Well, if it's just the board of directors, then that's outside RECA's jurisdiction. So unfortunately, there's no governing body specifically for condominiums yet. There are whispers of a tribunal being put in place. But RECA's jurisdiction is very limited to manager conduct. So if there's fraud going on and the managers can't do anything about it or is not involved in it, it's just completely outside RECA's jurisdiction.
Perfect. Anything to add there, Rose, or?
No, that's exactly correct.
And just, I guess, a couple statements from a fellow property manager is that Carissa Shine, thank you. There is a bulletin on graduated licensing, and also RECA does send out a bulletin with the complaints and issues regularly in emails. Now, I don't know if those are available to the public, but I think they are. But Rose, maybe you can.
Yeah, I think you might just need to subscribe to receive those notifications on them as well. Like automatically as licensed members, you receive them, and we're highly encouraged to read through them as well so that we know what kind of sanctions and decisions are being made in our industry.
Good, thank you. About self-managed condos again, can the board member go directly to RECA? I do think you answered this, Dionne, but maybe just expand on it.
You could go to RECA, but my thought is they're going, like, there's nothing preventing you from making a complaint, but my thought is they probably won't investigate that because they will deem it outside their scope.
Yeah, okay. Why does RECA get involved in fraud complaints against a manager?
Well, it's basic conduct requirements, right? I mean, fraud is, you're not supposed to engage in fraud as a professional, period. And I can't even point to the specific provisions, but sort of a no-go. So clearly, RECA doesn't want people who've been involved in fraud or even breach of trust managing condominiums, because those managers are usually in charge of the substantial assets.
Rose, anything further there? No? Okay. Yeah, I guess the one thing, sitting on ACMEC and speaking with the government and RECA, the property manager licensing was to come out to set that standard of professionalism similar to other occupations out there. So again, that would be why I would think RECA would be involved to, as Dionne mentioned, take away that license should there be an issue.
Well, and I think that's consumer driven too, Tony.
Yeah.
Like, those consumers were the ones saying, like, we need something in place. So, I mean, RECA was the one chosen. They're not the ones that initiated this.
No, sorry, Service Alberta. Yeah, Service Alberta. Where can one find if a property manager is licensed?
Go right on their website, on the RECA site, and search for a professional under their name, under the city, by brokerage. There's lots of avenues of locating them, because sometimes you don't know the correct spelling of the name.
And I think I just saw a chat bubble pop up with a link to the lookup site.
Also, my understanding with the links, that there was a lot of handouts, and thank you to our presenters for that information, the additional information they provided. My understanding is CCI there'll be an email coming out that have those links in it, and potentially an additional slide added after that'll be on the website with those links if you weren't able to copy them all, get them all added. So, wow. Last question here to Dandy. Does RECA handle complaints against developer-controlled boards? The comment is our board has been denied a request for an AGM.
I don't know if Dionne, you kind of on a legal end would know more on that.
Well, I guess it depends. Like, they're not going to get involved in just a sheer developer owner complaint because there's no manager involved. If there is a manager involved, I guess the answer is potentially, because that is within RECA's jurisdiction. Again, there has to be a manager action to be in there. Now, if a complaint is made and the manager says, well, we're just taking instruction from the board and we did or we didn't agree because of XYZ, then that may be the place where RECA's investigation stops. But there is also, on Service Alberta, there is a process to make complaints about developers. It's through their consumer protection portal. And I didn't think to bring that link, but it is a link that I could add into the mass email that goes out in the future. So it's new for Service Alberta too. So I personally haven't we did try to make one complaint and didn't go very far, but it's certainly worth a shot.
And just to add to that too, like, for example, if the owners do want to have that first meeting turnover and it's been denied, you can go ahead and, force that to happen. So, that's another avenue rather than going through all of the complaint process. Just make it happen and create your board.
Just to be cognizant of everyone's time, it is 1:00. We are going to be doing some more. The presenters have agreed to answer a few more questions. They'll take us past, but just before everyone does leave, we would like to take the opportunity again to thank the Alberta Real Estate Foundation for their grant that allows us to do this, and would also like to, again, while everyone's on, thank Dionne and Rose for taking time out of their busy schedules to do this, to provide us with the helpful information. And again, your professionalism comes shining through on these and your preparation. There have been a number of comments too, thanking you guys for being so well prepared. So thank you. There's two more questions, there's two more here. One of them, is there a listing that talks about the services that are qualified as that of a manager versus an administrator?
Like an administrator of a condominium, it depends what you mean by administrator. And so you need a little bit of clarity about that, because there is a process under the Condominium Property Act where you can appoint an administrator. So I'm not sure if that's what
I think this relates more to the manager versus their administration, like support in office.
Oh, I see. Okay.
Which would be there's actually a bulletin on licensed, unlicensed condominium manager duties. So there is, I'm sure that link was provided as well as part of the handouts.
Is there any way the gentleman who asked that question could just further there on the administrator? And if they are doing that, in the meantime, I'll ask another question that's come up. What if potentially the developer is acting in the capacity of a manager? So, for example, engaging in condo manager duties such as collecting fees, etc.
Again, interesting question. Potentially, because then
they're not typically, right, Dionne? Like they would typically be collecting maintenance fees.
Yeah, well, I'm just like before, like normally speaking, when you have a residential project, you will have a turnover process where it's the management company who's the intermediary collecting fees. Prior to that, the developer would have been the sole owner. If there is no management company at all involved and the developer is acting as manager, I guess potentially there could be a complaint made for unlicensed practice. But I will say that one is pretty fact dependent.
Because wouldn't they be acting more as a self-managed board because they're the elected board at the time?
Yeah, but then but then there's other owners. Yeah, that's a hard one. Oops. My lights went off there. There we go. Yeah, that's a hard one.
Yeah, a little bit clarification, I guess, on one of them. The developer owns the management company in this situation.
Oh, okay. Well, then if there is a separate management company owned, then again, they should be registered through RECA. I would imagine they would be. And if they are registered through RECA, then yes, they would be subject to RECA's jurisdiction. Whether or not there is a valid complaint there, I don't know, because there can be a host of reasons as to why an initial AGM hasn't been called. One of those is related to a change in the act that occurred in 2020. And so there isn't clarity as to when an AGM needs to be called if the developer still has a majority of the unit factors. And that has nothing to do with management.
Perfect. Well, thank you. Obviously, some great questions. I know there is a poll again that is going to come up just to see, after the webinar, how much everyone has learned or changed kind of their opinions. But again, thank you to Dionne and Rose. Thank you to CCI North as well for helping facilitate this on Zoom. So yeah, please feel free to fill out that poll. And if I'm not mistaken, I think that is it. Please let me know if there's anything else. I'm not seeing any other questions. Oh, I'm not seeing any other directions. So again, please finish the poll and thank you, everyone. Enjoy the afternoon. Enjoy the rest of summer that seemed to have flown by. So thank you all very much for attending. Have a great day.
Thank you.
Thanks, Tony. And thanks to Rose. She did the heavy lifting down the slides. So
thanks, Dionne. Thanks, Tony.
Thank you both. Fantastic job. Fantastic job.